This is Michael Popok, Legal AF. Donald Trump and his lawyers are scared to have the evidentiary hearing presented by the special counsel before Judge Chutkan in August to lay out all of the evidence and witnesses against Donald Trump before the election. We got new reporting coming out that they have a plan that they are about to launch in August when Judge Chutkan gets the D.C. election interference case back with the instructions from the United States Supreme Court in their July 1st immunity decision, in which they've told the judge she needs to carefully sort through, perhaps with an evidentiary hearing, whether any part of the indictment or all parts of the indictment fall into one of three categories. Core presidential conduct that has absolute immunity. And the court already gave her an example in the conversations between Donald Trump and the Department of Justice at the time in order to interfere with the peaceful transfer of power. They've already given that immunity. Official conduct, which has a very high burden that the prosecutor may never be able to meet to prove that that conduct is not immune. So look for Donald Trump to push everything into absolute immunity or core official conduct immunity buckets. And then this last little bucket is, can the judge figure out which parts of the indictment go to private or unofficial conduct? Now, we had reported earlier, and I did a hot take on the evidentiary hearing that the judge is likely to conduct. And I'm sure that the special counsel's office is chomping at the bit to put on witnesses like Mike Pence and Mike Roman and John Eastman and Rudy Giuliani and others who testified, along with all the other people who are going to testify about the pressure campaign by Donald Trump on them, election and elected officials, fake electors, and the rest. And that is what Donald Trump does not want the American people to see in terms of evidence presentation before the election or ever. Now, the timing of this, we have to follow the timing of this. As soon as the Supreme Court made their decision on July 1, there was a 25-day ticker that was running. 25 days before that decision became final and is entered as final, plus another 7 days. So you're talking about 32 days, 33 days or so from July 1 is when Judge Chutkan is going to get the case back, the D.C. election interference case with the 4 counts. And she's got some work to do. First of all, she's got a whole pileup of motion practice that the special counsel's office had filed and Donald Trump had filed for discovery and documents and motions to dismiss that all got put on ice back when, many months ago, when Trump filed his motion on immunity grounds and supremacy clause grounds to have the case dismissed. So she's got to catch up with all of that, some of which has been fully briefed, some of which has not been fully briefed. She's got that to do. The Supreme Court has told her, while you're there, take a look at the 4 criminal counts in the indictment, 2 of which are for obstruction of an official proceeding, which is now on life support because the Supreme Court ruled in a case called U.S. versus Fisher or Fisher versus U.S. that unless you can show interference with the integrity of the certificate counting process, including the use of false evidence, like fake elector certificates, you can't use that count unless there's actual document destruction, evidence destruction in the crime. And that's why almost all of the Jan 6 defendants, insurrectionists that attacked the Capitol are going to have that count likely dropped, although the Department of Justice is still thinks they've got a way to thread that needle. With Donald Trump, because he used fake elector certificates, that seems to fit, but the judge is going to have to make that decision based on some rulings within Fisher itself that said if you use fake evidence, that can satisfy the interference with obstruction with an official proceeding count, which is 2 of Donald Trump's 4 counts. And then you've got the issue of how you sort through in the waterfall of indicted activities, how you drop them into the various buckets. What is core conduct? What is official conduct? What is unofficial conduct and therefore a prosecutable crime? And that is what the judge is going to have to do. And that is what Donald Trump's lawyers it's now slipped out, is their strategy in August. Let's say in first week in August, when the judge calls everybody back into court to talk about how to move this case forward, they're going to argue for no evidentiary hearing, no airing of the evidence, no witnesses, no documents at all. They're going to say this can be completely resolved in briefing. And you don't need to bring in the parade of mini trial witnesses that the Department of Justice wants to do, because the Department of Justice knows they're not going to get a trial up and running. If Judge Chutkan doesn't even get the case back in front of her in her courtroom until August, it's going to be very difficult, if nigh impossible, to get it up and running before November 5. I've been working to lead a heart healthy lifestyle by getting more steps in, but finding the energy to pull it all off has been a struggle. We often think living a more heart-healthy life means making big, unsustainable changes. With Super Beets Heart Chews, you can get daily blood pressure support in just 2 tasty chews a day. And they even promote heart-healthy energy without the stimulants. Paired with a healthy lifestyle, the antioxidants in Super Beets are clinically shown to be nearly 2 times more effective at promoting normal blood pressure than a healthy lifestyle alone. Heart health has been top of mind for me, since I want to be able to enjoy the activities I love, including my time with my wife and newborn daughter. That's why I love Super Beets Heart Chews. They provide the energy boost I need to make healthy changes without any stimulants. Double your potential with Super Beets Heart Chews. Get a free 30-day supply of Super Beets Heart Chews on all bundles and 15% off your first order by going to getsuperbeets.com and using code LEGALAF. That's getsuperbeets.com, code LEGALAF. Now, the Department of Justice has already let it out that they are full steam ahead. And they don't believe November 5 is their cutoff date. They believe January 20 at 11:59 a.m. on inauguration moment is their cutoff. And they want to get that case up and running before it can be killed by Donald Trump. They're already going to get a tremendous amount of pressure and flack, and that whole lawfare weaponization of the Department of Justice by Joe Biden's Attorney General pressure if this thing lingers beyond the election, especially if somehow Donald Trump pulls out a win. But they're willing to do it. We gave a lot of grief to Merrick Garland, didn't start the prosecution fast enough, didn't appoint the special counsel fast enough, should have let Maine Justice do the case, didn't need a special counsel. But if he hangs in there and with this oncoming barrage of fire to keep the case on track all the way through January, that's saying something. But here the reporting is that they are going to try to argue to the judge and try to cut the knees and try to cut the legs out from under the prosecutor, right at the knees on their case. We don't need an evidentiary. We don't want witnesses, Your Honor. What witnesses? There's nothing to see here. We'll do it in briefs. We write briefs, they write briefs, they cite to evidence, we cite to evidence. That's it. They're going to have to do that. Because if the prosecutors treat this the way I think they're going to, which is this is our last chance to present the evidence to the American people before the election. They're going to want a full-blown mini trial. So there's going to be this debate, this very vigorous debate that we're going to be able to report on here on the MeidasTouch Network in August in the courtroom for Judge Chutkan about what the shape and the contours of her hearing look like. Is it just briefing about which falls into core official and unofficial conduct in the indictment? Is it something else? Is it this full-blown evidentiary hearing, which the Supreme Court has suggested, I would say, has commanded the trial court to conduct? I think she can point to elements in the Supreme Court ruling of Trump versus U.S. and say, gentlemen, I hear you. I hear you, Mr. Trump, and your lawyers. You don't want me to put on a trial. And I'm not going to put on a trial, but I have an obligation that's now been handed down to me by a mandate by the United States Supreme Court, my bosses, to go through carefully and methodically the indictment and to figure out what, if anything, survives. And the only way I know to do that is, yes, you can brief it, but I got to hear from witnesses and I got to see documents in my courtroom. And then we can get down to the nitty-gritty, because we know, Mr. Trump, that you're going to argue that everything is core or official conduct. in order to escape prosecution. And on the other side, the prosecutors are going to be able to tell me, I'm talking like Judge Chutkan now, they're going to be able to show me why everything in their indictment, maybe except for a couple of allegations, a couple of overt acts, falls outside the outer boundaries of official conduct, right? And isn't core presidential conduct as expressed in the Constitution, and therefore prosecutable. And that's going to be the push-pull. And now I got to figure out as the judge how I'm going to allow that to be presented to me so that I can make a proper record, so that the Supreme Court knows what the record is in case anybody in this room decides they're going to appeal again. I think that's the approach Judge Chutkan's going to make. We'll be able to report on it. There's no audio, there's no video, but we get reporting from inside the room. Sometimes some of our MeidasTouch legal contributors end up in the room, and we're able to find out with pretty much reliability, sort of a makeshift transcript. And then we're able to analyze it on Legal AF, our podcast on Wednesdays and Saturdays at 8 p.m. Eastern Time, and hot takes just like this one. So we'll continue to follow it, but that's the new reporting coming out of The Guardian and some other places, that Donald Trump is going to try, no surprise, to avoid and preclude and suppress the American people to know what he did that supports the indictment for election interference and his failure to peacefully transfer power. I'm Michael Popok, Legal AF. Leave me a thumbs up and a comment if you like what we're doing here. It helps us build the network, the algorithm. If you watch this video all the way through, that helps too. And then you can follow us on Legal AF Wednesdays, Saturdays, this YouTube, 8 p.m. Eastern Time, and then on audio podcast platforms of your choice. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.